natural life. The now 14-year-old Lionel Tate was sentenced to life in prison without the possibility of parole. The judge's
On July 28, 1999, in Pembroke Park, Florida, 12-year-old Lionel Tate was playing with his 6-year-old neighbor Tiffany Eunick while his mother, a Florida Highway Patrol trooper, was upstairs sleeping. What began as playful roughhousing would end in tragedy, setting the stage for one of the most controversial juvenile prosecutions in American history. At 10:54 p.m., Kathleen Grossette Tate came downstairs to check on the children and found Tiffany motionless on the floor. She immediately began CPR and called 911. Paramedics arrived to find the little girl with a fractured skull, a lacerated liver, broken ribs, and internal bleeding. Despite their efforts, Tiffany was pronounced dead at the hospital. When questioned by Broward County Sheriff's detectives, Lionel initially claimed he had been practicing wrestling moves he'd seen on television, body slams and elbow drops like those performed by his heroes, Dwayne "The Rock" Johnson and Hulk Hogan. He insisted he hadn't meant to hurt the much smaller girl. Dr. John Maricini, the county's chief medical examiner, reached a different conclusion after examining Tiffany's body. In his official report, he noted that her injuries were comparable to those sustained in high-speed car crashes or falls from multi-story buildings, not from playful roughhousing. These were among the most severe injuries I've seen in a case involving children, Dr. Maricini testified during the subsequent trial. The force required to inflict this level of damage goes far beyond mimicking television wrestling. Prosecutors, led by Assistant State Attorney Ken Padowitz, made the decision to try Lionel as an adult for first-degree murder. They rejected a plea deal that would have placed him in juvenile detention for 3 years, followed by 10 years of probation, counseling, and monitoring. Lionel's mother, believing in her son's innocence, supported this rejection. The state offered what I considered a lenient plea agreement, Padowitz later told the South Florida Sun-Sentinel. When that was rejected, we had no choice but to proceed with the evidence we had, which pointed to intentional, not accidental, violence. The trial began on January 5, 2001. Lionel, now 14, sat quietly as jurors viewed autopsy photos and heard testimony about Tiffany's 35 separate injuries. His defense attorney, Jim Lewis, maintained that Tiffany's death was a tragic accident, the result of a child not understanding his own strength or the consequences of his actions. After less than 3 hours of deliberation, the jury found Lionel Tate guilty of first-degree murder. 2 months later, Judge Joel Lazarus sentenced him to life in prison without the possibility of parole. At the time, the youngest American ever to receive such a sentence. The acts of Lionel Tate were not the playful acts of a child, Judge Lazarus stated during sentencing. They were cold, callous, and indescribably cruel. The case ignited immediate national controversy. Child advocates pointed out that at 12, Lionel was too young to see a PG-13 movie alone, yet was being sentenced to die in prison. Numerous organizations, including Amnesty International and the NAACP, condemned the sentence as excessive and inappropriate for a juvenile offender. In December 2003, Florida's 4th District Court of Appeal overturned Tate's conviction, ruling that his competency to understand the legal proceedings should have been evaluated before trial. In January 2004, Tate accepted the plea deal he had previously rejected, pleading guilty to second-degree murder and receiving a sentence of 3 years in prison, which he had already served, and 10 years of probation. But Tate's story didn't end with his release. In 2004, he was arrested for violating probation after being found with a knife. In 2005, he was charged with armed robbery and assault for robbing a pizza delivery person at gunpoint. He was subsequently sentenced to 30 years in prison for these violations. As of August 2025, Lionel Tate remains incarcerated at the Everglades Correctional Institution in Florida. His case continues to be cited in debates about juvenile justice reform, the culpability of children, and the long-term consequences of treating young offenders as adults. The Tate case represents a troubling dichotomy in our legal system, said Barry Feld, professor of law at the University of Minnesota, in a 2019 analysis. We recognize that children lack the judgment, maturity, and impulse control of adults in virtually every legal context except criminal responsibility.
Devoted to wishing peace and healing upon you all. My hopes, fears, and wishes probably mean nothing to you, but they...
On the evening of November 3rd, 1998, in Jacksonville, Florida, 8-year-old Maddie Clifton disappeared from her suburban neighborhood. For 7 days, hundreds of volunteers combed the area searching for the missing child, while her face appeared on missing person flyers throughout the city and on national television. The answer to her disappearance lay just 40 yards away from her home, in the bedroom of 14-year-old Joshua Phillips, a quiet, seemingly unremarkable boy who had joined in the search efforts for Maddie. On November 10th, Phillips's mother, Melissa, was cleaning her son's room when she noticed a wet spot on the base of his waterbed. As she inspected it further, she made a horrifying discovery: the decomposing body of Maddie Clifton concealed inside the waterbed platform. Melissa Phillips immediately called the police. Within hours, Joshua was in custody. During interrogation, the teenager confessed to killing Maddie, providing a detailed account that would later be entered into evidence at his trial. According to official police reports, Phillips claimed he had been playing with Maddie when he accidentally struck her with a baseball. When she cried out, he panicked, fearing his father's strict punishment. In a desperate attempt to silence her, he dragged her into his home, struck her repeatedly with the baseball bat, and then stabbed her multiple times with a knife from his kitchen. Medical examiner reports confirmed that Maddie had been stabbed at least 11 times and suffered blunt force trauma to her head and neck. This was a crime that shocked our community to its core, said then State Attorney Harry Shorstein during a press conference announcing his decision to try Phillips as an adult. The deliberate and repeated nature of the violence, followed by the calculated concealment of the victim's body, demonstrates a level of criminal sophistication that demands adult consequences. Due to the severity of the crime, Phillips was automatically transferred to adult court under Florida's tough juvenile transfer laws. There was no hearing to determine whether juvenile or adult court was more appropriate. The transfer was mandatory based solely on the charge. Phillips's trial began on July 6, 1999. His defense attorney, Richard Nichols, did not dispute that Phillips had killed Maddie, but argued that the crime was not premeditated. This was a panicked child who made a terrible mistake and then made increasingly worse decisions trying to hide that mistake, Nichols told jurors. The prosecution painted a different picture, emphasizing the brutality of the attack and the calculated way Phillips had hidden the body and participated in search efforts. After just 2 hours of deliberation, the jury found Phillips guilty of first-degree murder. Judge Charles Arnold sentenced him to mandatory life imprisonment without the possibility of parole. Phillips was 14 years and 354 days old when he was sentenced to die in prison. The legal landscape for juvenile offenders would change dramatically in the years after Phillips's sentencing. In 2005, the U.S. Supreme Court ruled in Roper v. Simmons that executing offenders for crimes committed as juveniles was unconstitutional. In 2010, Graham v. Florida prohibited life without parole sentences for juveniles convicted of non-homicide offenses. And in 2012, Miller v. Alabama held that mandatory life without parole sentences for juvenile homicide offenders violated the Eighth Amendment's prohibition on cruel and unusual punishment. Based on these landmark decisions, Phillips became eligible for resentencing. In 2017, nearly 19 years after Maddie's murder, Phillips appeared before a judge again. Now 33 years old and having spent most of his life in prison, he expressed remorse for his actions. Judge Wardell Wallace resentenced Phillips to 40 years in prison with the possibility of judicial review after 25 years. The Supreme Court has made clear that juvenile offenders, even those who commit terrible crimes, must be given some meaningful opportunity to demonstrate rehabilitation, Judge Wallace noted in his ruling. As of August 2025, Joshua Phillips remains incarcerated at the Wakulla Correctional Institution in Florida. His case has become a focal point in ongoing debates about how the justice system should handle violent juvenile offenders. The Phillips case demonstrates the evolution in our understanding of juvenile culpability, said Marsha Levick, co-founder of the Juvenile Law Center, in a 2022 interview. We now recognize that even juveniles who commit serious violent crimes have the capacity for change, and our sentencing practices must reflect that potential. On February 6, 1996, in the small agricultural town of Moses Lake, Washington, 14-year-old Barry Dale Lukaitis walked into his Frontier Middle School algebra class wearing a long black duster coat. Concealed beneath it were 2 pistols, 78 rounds of ammunition, and a high-powered rifle. "This sure beats algebra, doesn't it?" Lukaitis reportedly said, a line borrowed from the Stephen King novel Rage, before opening fire. In the next few minutes, he killed 2 classmates, 14-year-old Arnold Fritz and 14-year-old Manuel Vela, and his algebra teacher, 49-year-old Leona Caras. He also critically wounded another student, 13-year-old Natalie Hintz, before taking the remaining students hostage. The shooting ended when gym teacher John Lane entered the classroom to investigate. Lukaitis pointed his rifle at Lane, but the teacher charged him, wrestled him to the ground, and disarmed him. Lane then held Lukaitis until police arrived. The entire incident, from the first shot to Lukaitis' surrender, lasted approximately 10 minutes, but its impact would be felt for decades. "I just wanted the kids to know what it was like to be bullied," Lukaitis later told police in a recorded statement. "I wanted to teach everyone a lesson about what happens when you're mean to people." The investigation revealed a troubled adolescent whose descent toward violence had been documented in his school writings and personal journals. He had been diagnosed with clinical depression and had expressed suicidal thoughts. His parents had recently separated in a bitter divorce that had profoundly affected him. Most disturbingly, Lukaitis had meticulously planned the attack. He had practiced shooting with his father, carefully selected his targets, and chosen February 2nd because it was a Friday, the day report cards were issued. His preparations included sewing extra ammunition pouches into his duster coat and rehearsing his movements through the school hallways. Grant County prosecutor John Nodal made the immediate decision to try Lukaitis as an adult. The premeditated nature of this crime, the multiple victims, and the danger to the community all point to an adult-level prosecution, Knodel stated in court filings seeking the transfer from juvenile court. Defense attorneys Michael Frost and Garth Dano fought the transfer, arguing that Lukaitis' age and documented mental health issues made him an appropriate candidate for the juvenile system. However, after reviewing the evidence, Superior Court Judge Michael Cooper ordered the transfer to adult court. The trial began on September 3, 1997. Lukaitis' defense team pursued an insanity plea, presenting expert testimony about his depression, his family history of mental illness, and his detachment from reality. They argued that his obsession with violent media, including the King novel and Pearl Jam's music video for Jeremy, which depicted a school shooting, had blurred the lines between fantasy and reality for the troubled teen. Prosecution witnesses countered with evidence of Lukaitis' careful planning and clear statements showing he understood the wrongfulness of his actions. After a 3-week trial, the jury rejected the insanity defense and found Lukaitis guilty of 3 counts of aggravated first-degree murder and 1 count of attempted murder. On October 10, 1997, Judge Cooper sentenced Lukaitis to 2 life sentences plus 205 years in prison without the possibility of parole. Lukaitis, now 16, showed no emotion as the sentence was read. The planning and execution of these murders reveal a level of calculation that is particularly disturbing in one so young, Judge Cooper said during sentencing. The court cannot ignore the severity of these crimes or the loss suffered by the victims' families. The Frontier Middle School shooting occurred 2 years before the Columbine High School massacre would bring national attention to school shootings. In many ways, Lukaitis' attack foreshadowed the wave of school violence that would follow, including the elements of bullying, mental illness, access to firearms, and the influence of violent media. Following the 2012 Miller v. Alabama Supreme Court decision prohibiting mandatory life sentences for juvenile offenders, Lukaitis became eligible for resentencing. In 2017, after more than 20 years in prison, he was resentenced to 189 years in prison, still effectively a life sentence, but one that complied with the Supreme Court's guidelines by considering his youth at the time of the crime and allowing for the theoretical possibility of release. During his resentencing hearing, Lukaitis spoke publicly about his crimes for the first time in decades. "I've spent my time in prison trying to understand why I did this horrible thing," he told the court. "There's no justification for what I did. There's no way to make it right. I can only say I'm sorry to everyone I hurt, and I know that doesn't change anything." As of August 2025, Barry Dale Lukaitis remains incarcerated at the Clallam Bay Correction Center in Washington State. His case continues to be studied by experts in juvenile criminology, school security, and adolescent mental health. The Lukaitis case represents a tragic convergence of factors we now recognize as risk markers for school violence, said Dr. Catherine Newman, author of Rampage: The Social Roots of School Shootings, in a 2020 interview. Family disruption, untreated mental illness, access to weapons, and social isolation all contributed to this tragedy.
To Eric's confession, the question remains, what could possibly compel this child to kill another?
Does he know what he's done? Does he know it's wrong?
On August 2nd, 1993, in the small village of Savona in upstate New York's Steuben County, 4-year-old Derek Roby set out alone for a summer recreation program at a park just a block from his home. The short walk was one he had made many times before, but on this day, he never arrived. When program supervisors called Derek's mother to report his absence, a frantic search began. Hours later, searchers discovered Derek's body in a wooded area near the park. He had been strangled, his head had been crushed with large rocks, and his body had been sexually assaulted with a stick. The small community of Savona, population 822, was paralyzed with fear and grief. For 2 weeks, police had no substantial leads. Then, on August 16th, they interviewed 13-year-old Eric Smith, a local boy with distinctive red hair and thick glasses who had been seen near the park on the morning of the murder. After extensive questioning, Smith confessed to the crime in a videotaped interview that would later be played for a horrified jury. According to police records and trial testimony, Smith admitted to luring Derek into the woods by offering to show him a shortcut to the park. Once isolated, Smith strangled the younger boy, smashed his head with rocks, and violated his body, all without any clear motive. When asked why he had killed Derek, Smith simply said, "I don't know. I just wanted to know what it felt like." Steuben County District Attorney John Tunney made the immediate decision to charge Smith with second-degree murder as a juvenile offender, the maximum charge possible given his age. Under New York law at that time, children under 14 could not be tried as adults, but they could be prosecuted as juvenile offenders in adult court for certain serious crimes, including murder. This was not a childish mistake or a momentary lapse in judgment, Tunney explained to reporters at the time. The deliberate and brutal nature of this crime requires the most serious response our legal system allows for someone of Eric's age. Smith's trial began on August 16, 1994, exactly 1 year after his confession. His defense team, led by attorney Kevin Bradley, did not dispute that Smith had killed Derek, but argued that he suffered from intermittent explosive disorder, a mental condition characterized by uncontrollable bursts of violence. They presented evidence that Smith had been severely bullied throughout his childhood and had exhibited troubling behaviors from an early age. Dr. Stephen Herman, a psychiatrist who evaluated Smith, testified that the boy suffered from an explosive rage disorder that compromised his ability to control his actions. Eric has a biological disorder of the brain, Dr. Herman told the court. He was unable to appreciate the consequences of his conduct. Prosecutors countered with testimony from their own psychiatric experts who diagnosed Smith with conduct disorder but maintained he knew right from wrong. They emphasized the premeditated nature of the crime and Smith's attempts to cover his tracks afterward. After 9 days of testimony and 7 hours of deliberation, the jury rejected the mental illness defense and found Smith guilty of second-degree murder. Judge Donald Purple sentenced him to the maximum term, 9 years to life in prison. At 14, Eric Smith became one of the youngest murderers in New York State history. The case triggered extensive debate about how the justice system should handle violent juvenile offenders, particularly those who show signs of serious mental illness. It also raised difficult questions about the role of bullying and childhood trauma in the development of violent behavior. Eric Smith exemplifies the challenge of distinguishing between a child who is truly evil and one who is severely damaged, said Dr. Lewis Krauss, a forensic psychiatrist who later studied the case for the American Academy of Child and Adolescent Psychiatry. The justice system often struggles to make this distinction. Smith first became eligible for parole in 2002 at age 22. His applications were denied 11 consecutive times as the parole board consistently found he had not shown sufficient remorse or understanding of his crime. During these hearings, Derek Roby's parents, Dale and Doreen, appeared regularly to oppose his release. "No sentence, no matter how long, can bring back our son," Dale Roby told the parole board in 2012, but keeping Eric Smith in prison protects other children from suffering Derek's fate. Finally, in October 2021, at his 12th parole hearing, Smith was granted release. By then, he had spent 28 years, more than 2/3 of his life, in custody. The parole board cited his completion of extensive rehabilitation programs, his expressions of remorse, and his concrete plans for reintegration into society. In February 2022, at age 42, Smith was released under strict supervision conditions, including a prohibition on contact with anyone under 18 and mandatory registration as a sex offender. As of August 2025, he lives in a structured residential facility in New York State, where he continues to receive mental health treatment. Eric Smith's case remains a landmark in juvenile justice history, regularly cited in legal and psychological literature exploring the intersection of childhood development, mental illness, and violent crime.
Prosecutors have used Price's violent outbursts to their advantage. Each time he gets into trouble, he violates probation and extra time is tacked onto his sentence.
In the quiet suburbs of Warwick, Rhode Island, a 13-year-old boy became one of the nation's youngest serial killers, committing crimes so brutal they would permanently alter that state's juvenile justice laws. On July 27, 1987, police responded to a call at 55 Inez Avenue. Inside, they discovered the bodies of 39-year-old Rebecca Spencer and her 2 daughters, 10-year-old Joan and 8-year-old Jennifer. All 3 had been stabbed multiple times, Rebecca 58 times, Joan 62 times, and Jennifer 30 times. The murder weapon, a kitchen knife, had been left at the scene. The community was paralyzed by fear. 2 years earlier, in December 1985, another Warwick resident, 27-year-old Rebecca Spencer, no relation to the other victims, had been found stabbed 58 times in her home, just 2 doors down from where the Beardsleys lived. That crime had never been solved. For weeks, investigators had few leads. Then, on September 1st, 1987, they brought in Craig Price, a 13-year-old who lived just 500 feet from both crime scenes. Price had a history of break-ins and had been seen in the area on the nights of both murders. Under questioning, Price confessed to all 4 killings. According to police reports and court records, he provided details only the killer would know, including the exact number of stab wounds and the placement of the bodies. He also led police to a shed in his backyard where he had hidden items taken from the Beardsley home, including bloody clothing. When asked why he had committed the murders, Price's response was chilling in its banality. He told detectives he had broken into the Spencer home looking for money and had killed her when she woke up. 2 years later, he broke into the Beardsley home with the same intention and killed all 3 occupants to eliminate witnesses. Price's confession presented Rhode Island authorities with an unprecedented legal dilemma. Under the state's juvenile justice laws at the time, the maximum penalty for any crime committed by someone under 16 was detention until age 21. This meant that Price, despite confessing to 4 brutal murders, could potentially be released after just 7 years. The system wasn't designed to handle a 13-year-old serial killer, said then Rhode Island Attorney General James O'Neill in a statement that would be widely quoted in subsequent legislative debates. The law assumed that juvenile offenders committed juvenile crimes, not premeditated multiple homicides. Due to his age and the existing law, Price was adjudicated in family court as a delinquent rather than being tried as an adult. On September 21, 1989, family court judge Thomas Fay ordered Price to be held at the Rhode Island Training School until his 21st birthday, the maximum sentence possible under state law. The public outcry was immediate and intense. The prospect of a confessed quadruple murderer being released after just 7 years of confinement sparked protests and demands for legislative reform. In response, the Rhode Island General Assembly passed what became known as the Craig-Price Law in 1990, allowing family court judges to impose adult sentences on juvenile offenders to be served after they turn 21. This legislation couldn't be applied retroactively to Price, but prosecutors found another way to extend his incarceration. While in custody, Price committed numerous infractions, including assaults on guards and other juveniles. For these acts, he was charged and convicted as an adult, receiving additional prison time that extended well beyond his original release date. In 1994, Price attacked a corrections officer, leading to a conviction for criminal contempt and an additional 25-year sentence. In 1998, he assaulted another inmate and received another 25-year sentence. In 2009, he pleaded no contest to stabbing an inmate at the Florida prison where he had been transferred, adding 10 more years to his sentence. Psychological evaluations conducted throughout Price's incarceration painted a disturbing picture. Dr. Richard Millman, who examined Price for the court, testified that he exhibited a complete lack of remorse, empathy, or emotional connection to his crimes. Other experts diagnosed him with antisocial personality disorder and noted his high risk for recidivism. Craig Price represents an unusual and particularly concerning case of early-onset violent psychopathy, wrote Dr. Robert Hare, creator of the Psychopathy Checklist and a leading expert on psychopathic behavior, in a 2005 review of the case. The combination of predatory violence, lack of remorse, and onset before adolescence is extremely rare and particularly concerning from a public safety perspective. As of August 2025, Craig Price remains incarcerated at the Suwannee Correctional Institution in Florida. Now, in his early 50s, he has spent the vast majority of his life behind bars. His earliest possible release date, considering all his sentences, is 2056, when he would be in his early 80s. The Craig Price Law continues to influence juvenile justice in Rhode Island and has served as a model for similar legislation in other states. The case is regularly cited in debates about juvenile transfer laws and the tension between rehabilitation and public safety in cases involving extremely violent young offenders. The Craig Price case fundamentally changed how we think about juvenile crime, said Jeffrey Butts, director of the Research and Evaluation Center at John Jay College of Criminal Justice, in a 2019 interview. It challenged the assumption that violent crime by children is always the product of immaturity rather than deeply rooted pathology. On March 19, 1978, 15-year-old Willie Bosquet boarded a New York City subway train with a loaded .22 caliber handgun. By the end of the day, 2 men were dead, and a case that would permanently transform juvenile justice in New York, and eventually across the nation, had begun. According to police reports and court records, Bosquet first shot 23-year-old Noel Perez during an attempted robbery on the 3 train. 8 days later, on March 27th, he killed 46-year-old Moises Perez, no relation to the first victim, under similar circumstances. Both men were shot at close range while riding the subway, and both died from their wounds. Bosquet's crime spree continued with the non-fatal shooting of a subway employee during another robbery attempt and the armed robbery of a go-go bar in Harlem. On March 28th, police arrested Bosquet and his 16-year-old accomplice, Herman Spates, after a witness identified them. While in custody, Bosquet freely confessed to the murders, providing details that only the killer would know. His demeanor during the confession alarmed even seasoned detectives. He showed absolutely no remorse, noted Detective Robert Healy in his report. He discussed the killings as casually as if he were describing a movie he had seen. What Bosquet knew, and what shocked the public when it was later revealed, was that under New York's Juvenile Justice Reform Act of 1976, the maximum penalty he faced was just 5 years in a juvenile facility, regardless of the number or severity of his crimes. As a 15-year-old offender, he could not be tried as an adult, and state law mandated his release by age 21. Bosquet's case was adjudicated in family court, where Judge Harold Lynch had no choice but to impose the maximum available sentence, confinement at the Division for Youth's Goshen Center until Bosquet's 21st birthday. In practical terms, this meant that Bosquet would serve just 5.5 years for 2 cold-blooded murders. In court, Bosquet displayed the same chilling lack of remorse that had disturbed investigators. According to transcripts, he smiled throughout the proceedings and, upon hearing his sentence, reportedly told the judge, "I got a good deal, 5 years for 2 murders. That's not bad." The public and political reaction was swift and furious. New York Governor Hugh Carey called an emergency session of the state legislature, which quickly passed the Juvenile Offender Act of 1978, known informally as the Willie Bosquet Law. This groundbreaking legislation fundamentally altered the treatment of juvenile offenders in New York State by allowing children as young as 13 to be tried as adults for murder, setting the threshold at 14 for other violent felonies, establishing mandatory minimum sentences for juvenile offenders convicted of serious crimes, creating a presumption that serious juvenile offenders would be tried in adult rather than family court. The law was signed on July 20th, 1978, less than 4 months after Bosquet's crimes. It marked the beginning of a nationwide trend toward harsher treatment of juvenile offenders that would accelerate throughout the 1980s and 1990s. Bosquet's personal story only reinforced the public perception that some juvenile offenders were beyond rehabilitation. Released as scheduled in 1983, he almost immediately resumed his criminal behavior. In December 1983, he was arrested for armed robbery and assault. During his trial, he slashed his lawyer with a razor blade. This resulted in a 7 to 25-year adult prison sentence. His behavior in prison became increasingly violent. In 1988, he stabbed a prison guard and received an additional 25 years to life sentence. In 1994, he set fire to his cell and assaulted officers who responded, adding another 25 years to life term. With each new crime and sentence, Bosquet seemed determined to fulfill his own dark prophecy. During one court appearance, he declared himself a monster created by the system. Investigations into Bosquet's background revealed a deeply troubled childhood. His father, who had murdered 2 men, was in prison for most of Willie's life. His grandfather had died in the electric chair for murder. Bosquet himself had been in and out of juvenile institutions since age 9, with a record of more than 200 crimes before the subway murders. Despite this extensive contact with the juvenile justice system, he received little effective intervention for his escalating violent behavior. Willie Bosquet exemplifies both the failure of the juvenile justice system to identify and effectively treat high-risk children and the problem with an overly rigid, age-based approach to criminal culpability, said Franklin Zimring, professor at the University of California, Berkeley Law School, and author of American Juvenile Justice in a 2015 analysis. As of August 2025, Willie Bosquet remains incarcerated at the 5 Points Correctional Facility in New York, where he has spent most of his life in solitary confinement due to his continued violent behavior. Now, in his early 60s, he is serving multiple life sentences that ensure he will never be released. The Willie Bosquet law remains in effect, though subsequent reforms have moderated some of its harshest provisions. The case continues to be cited in debates about juvenile justice policy, the effectiveness of rehabilitation programs, and the complex interplay between environmental factors and individual responsibility in the development of criminal behavior.
One of the foster homes that I was in prior to being placed in her foster home was fairly abusive.
On February 19, 1997, in the remote town of Bethel, Alaska, 16-year-old Evan Ramsey carried a 12-gauge shotgun into Bethel Regional High School and committed one of the earliest school shootings of the modern era, a tragedy that would expose critical gaps in rural mental health services and forever change how Alaska addressed potential threats in its isolated communities. According to court records and police reports, Ramsey arrived at school shortly before 8:00 a.m. and proceeded directly to the student commons area. There, he shot and killed 15-year-old Josh Palacios, a popular basketball player. He then moved to the main office where he fatally shot Principal Ron Edwards. During his rampage, Ramsey also wounded 2 other students before surrendering to police who had arrived at the scene. The investigation that followed revealed a tragedy years in the making. Court records documented Ramsey's troubled childhood in disturbing detail. His father had been imprisoned for a standoff with police when Evan was just 7 years old. His mother struggled with alcoholism, leaving Evan and his brother to cycle through a series of foster homes where they experienced neglect and abuse. By age 10, Ramsey had attempted suicide. By 15, he had developed a reputation as a target for relentless bullying. Most disturbingly, the investigation uncovered evidence that Ramsey had not acted alone in planning the shooting. According to police interviews and subsequent court testimony, 2 of Ramsey's friends knew about his plans and had actively encouraged him. One had even provided him with instructions on how to use the shotgun. These friends had suggested targets and discussed the shooting with Ramsey for days before the attack, never alerting adults or authorities. This was a preventable tragedy, stated Alaska State Trooper Colonel Glenn Godfrey in his official report to the governor. Multiple warning signs were missed, and multiple individuals had knowledge that could have prevented this attack. Due to the severity of the crimes, Ramsey was automatically transferred to adult court under Alaska law. His trial began in December 1998, with prosecutors seeking the maximum penalty allowed. The defense team presented evidence of Ramsey's traumatic childhood, history of suicidal thoughts, and the role of peer encouragement in the shooting. After a 3-week trial, Ramsey was found guilty of 2 counts of first-degree murder and 15 counts of attempted murder. Superior Court Judge Mark Wood sentenced him to 2 99-year sentences for the murders, plus 12 years for the attempted murders, a total of 210 years in prison. The court recognizes the difficult circumstances of your upbringing, Judge Wood told Ramsey during sentencing. However, the deliberate taking of 2 lives and the attempted taking of many more requires a sentence that reflects both the severity of your actions and the need to protect society. The aftermath of the Bethel shooting prompted significant changes in how Alaska addressed school security and mental health, particularly in its rural communities. The state legislature passed the School Safety Act of 1998, which required schools to develop comprehensive safety plans, mandated reporting of threats against schools or students, established threat assessment protocols for all districts, created the Rural School Mental Health Initiative to increase access to counseling services in remote areas. The case also led to criminal charges against Ramsey's friends who had known about the attack but failed to report it, one of the earliest examples of authorities holding peers accountable in school shooting cases. Following the 2012 Supreme Court decision in Miller v. Alabama, which prohibited mandatory life sentences for juvenile offenders, Ramsey became eligible for resentencing. In 2018, after serving 21 years in prison, he was resentenced to 99 years with eligibility for discretionary parole after serving 49 years. This modified sentence acknowledged Ramsey's age at the time of the crime while still reflecting the severity of his actions. During his resentencing hearing, Ramsey spoke publicly about his crimes. "Not a day goes by that I don't think about Josh and Mr. Edwards and the pain I caused their families," he told the court. "I was a child filled with rage and hopelessness, but that doesn't excuse what I did. Nothing ever will." As of August 2025, Evan Ramsey remains incarcerated at the Spring Creek Correctional Center in Seward, Alaska. He is now in his mid-40s and has spent more than half his life in prison. His earliest possible parole date is 2046, when he will be in his mid-60s. The Ramsey case highlights the unique challenges of preventing violence in isolated communities, said Dr. Dewey Cornell, a forensic psychologist specializing in school violence, in a 2020 analysis. Geographic isolation can limit access to mental health services, complicate threat assessment, and delay intervention in crisis situations.
Three things could happen at Gingrich's hearing tomorrow. The judge could set him free. He could be transferred to adult prison to serve the rest of his 25-year sentence.
On April 20th, 2010, in a rural home in Kosciuszko County, Indiana, 15-year-old Colt Lundy and 12-year-old Paul Gingerick committed a crime that would spark a national debate about juvenile justice and lead to landmark legislation in their state. According to court records and police reports, the two boys shot and killed Lundy's stepfather, 49-year-old Philip Danner, as part of a plan to run away to Arizona. After the murder, they stole Danner's car and drove about 60 miles before being apprehended by police. The investigation revealed that Lundy had harbored resentment toward his stepfather and had recruited Gingerick and another boy to help him escape his home situation. Court documents showed that the boys met earlier that day to plan the murder, with Lundy providing 2 handguns from his stepfather's collection. When Danner returned home that evening, Lundy and Gingerick were waiting for him. As he sat at his computer, they shot him multiple times at close range. The third boy, who had been part of the planning but was not present for the murder, later provided critical testimony about the premeditation involved. The case immediately presented prosecutors with a difficult question. How should the justice system respond when a 12-year-old, a 7th grader, participates in a premeditated murder? Kosciuszko County prosecutor Dan Hampton made the controversial decision to charge both boys as adults. Under Indiana law at that time, children as young as 10 could be waived to adult court for certain serious felonies, including murder. The nature of this crime, its planning, execution, and the subsequent flight demonstrates a level of criminal sophistication that warrants adult prosecution, Hampton argued in court filings seeking the transfer. The decision sparked immediate controversy. Child advocates pointed out that at 12, Gingerick was too young to see a PG-13 movie alone, yet was facing a potential 65-year adult prison sentence. His defense attorney, Monica Foster, challenged the waiver to adult court, arguing that the rapid process had violated Gingerick's due process rights. The initial waiver hearing had lasted just minutes, and Gingerick, she contended, had not had adequate time to consult with his attorneys or understand the proceedings. Despite these objections, Gingerick's case was transferred to adult court, where, facing the prospect of decades in adult prison, he accepted a plea agreement. On November 3, 2010, he pleaded guilty to conspiracy to commit murder and received a 25-year sentence. Gingerick became the youngest person in Indiana history to be sentenced as an adult. The controversy surrounding his case did not end with his sentencing. In December 2012, the Indiana Court of Appeals took the extraordinary step of overturning Gingerick's waiver to adult court, finding that the rapid transfer process had indeed violated his due process rights. The court ordered a new waiver hearing that would give proper consideration to his age, maturity, and the circumstances of the crime. Rather than proceed with a new hearing and trial, prosecutors and defense attorneys negotiated an innovative solution. Gingerich became the first juvenile offender to be sentenced under a new Indiana law, one inspired by his own case, called the Paul's Law, or blended sentencing statute. This law created a middle ground between the juvenile and adult systems for certain young offenders. Under this new arrangement, Gingerich received a 30-year sentence to be served through a combination of juvenile and adult facilities, with mandatory review hearings to assess his progress toward rehabilitation. The law required that he begin his sentence in a juvenile facility, with transfer to an adult prison only if he failed to demonstrate rehabilitation. This case forced Indiana to confront a fundamental question about juvenile justice, said Joel Shum, a professor at Indiana University's Robert H. McKinney School of Law, in a 2015 analysis. Can a 12-year-old whose brain is still developing truly understand adult criminal proceedings and be held to the same standard of culpability as an adult? Gingerich's progress in custody became a test case for the rehabilitation-focused approach. By all accounts, he excelled in the juvenile system, completing his high school education, participating in extensive counseling, and showing genuine remorse for his actions. At each review hearing, judges noted his exemplary behavior and commitment to rehabilitation. In 2016, after serving 6 years, Gingerich was released from the juvenile facility and transferred to home detention with electronic monitoring. In 2018, he was allowed to move to supervised probation. By 2022, having served 12 years under various forms of supervision, he was granted early release for good behavior. As of August 2025, Paul Gingerich is in his late 20s and living as a free man. According to public records, he has maintained employment, continued his education, and had no further contact with the criminal justice system. His case is frequently cited in juvenile justice reform discussions as an example of successful rehabilitation. The law that bears his name has been used to sentence dozens of young offenders in Indiana, creating a more nuanced approach to juvenile cases that prioritizes rehabilitation while still acknowledging the seriousness of violent crimes. The Gingerich case demonstrates both the potential pitfalls of treating children as adults in the justice system and the possibility of meaningful reform growing out of controversy, said Marsha Levick, Deputy Director of the Juvenile Law Center, in a 2020 interview. It's a reminder that our legal response to juvenile crime continues to evolve as our understanding of adolescent development deepens. On February 20th, 2009, in the small town of Wampum, Pennsylvania, a horrific crime shook the community and launched a case that would become one of the most controversial juvenile prosecutions in American history. A case that would eventually end with a rare full exoneration. Kenzie Houck, 26 years old and 8 months pregnant, was found dead in her bedroom from a shotgun blast to the back of her head. Her unborn child did not survive. Houck's 4-year-old daughter discovered her mother's body and ran to neighbors for help. Within hours, police focused their investigation on an unlikely suspect, 11-year-old Jordan Brown, the son of Houck's fiancée. According to initial police reports, investigators found a shotgun shell casing on the path where Jordan would have walked to catch his school bus that morning. State police also noted that a youth model 20-gauge shotgun, which belonged to Jordan, was in the house with the smell of recent discharge. Based primarily on this circumstantial evidence, police arrested Jordan Brown and charged him with 2 counts of homicide. Lawrence County District Attorney John Bongivengo made the controversial decision to charge Jordan as an adult, which, under Pennsylvania law at that time, was required for homicide cases regardless of the defendant's age. If convicted, the 5th grader faced the prospect of life in prison without the possibility of parole. This is not a case where we can say, well, it's a juvenile, it's not as serious, Bongivengo told reporters at a press conference announcing the charges. 2 lives were taken. Jordan's father, Chris Brown, maintained his son's innocence from the beginning. He hired defense attorney Dennis Alisco, who immediately challenged the adult charges and questioned the strength of the evidence against his young client. The case quickly gained national attention, with legal experts and child advocates expressing alarm at the prosecution of an 11-year-old as an adult. After extensive legal battles, in August 2011, Judge Dominic Motto granted the defense motion to transfer Jordan's case to juvenile court, acknowledging that juvenile court would better serve the public interest given his age and potential for rehabilitation. Jordan's juvenile adjudication hearing began in April 2012, 3 years after the crime. By this time, his legal team had assembled a strong defense challenging the forensic evidence. They presented expert testimony that the gunshot residue testing was flawed and that the timeline presented by prosecutors was physically impossible given the bus schedule and witness statements. Despite these challenges, on April 13, 2012, Judge John Hodge found Jordan delinquent, the juvenile court equivalent of guilty, on charges of homicide and homicide of an unborn child. He was ordered to remain in juvenile detention until age 21, the maximum allowed under Pennsylvania law. Jordan's legal team, now led by attorney Stephen Colafella, immediately appealed the verdict. The appeal process would span 6 years and reveal fundamental flaws in the prosecution's case. In May 2013, Superior Court Judge John Bender raised serious questions about the sufficiency of the evidence, writing that the case against Jordan was based on pure speculation, rather than proof beyond a reasonable doubt. The case was remanded for further consideration. Years of legal battles followed, with Jordan's attorneys arguing that the prosecution had failed to establish basic elements of their case. No witnesses placed Jordan at the scene. Gunshot residue tests were inconclusive, and the timeline presented by prosecutors was contradicted by school bus records and witness statements. Finally, in July 2018, the Pennsylvania Superior Court unanimously overturned Jordan's conviction, ruling that the evidence was insufficient to support an adjudication of delinquency. The court stated that the prosecution's case was so weak that it shocked the conscience of the court. Even taking the Commonwealth's evidence as true, the court wrote, there is literally no evidence demonstrating beyond a reasonable doubt that Brown pulled the trigger. On July 20, 2018, prosecutors announced they would not pursue further charges against Jordan Brown. After 9 years, 4 months, and 28 days, Jordan, now 21 years old, was officially exonerated. The case had cost him his entire adolescence. From age 11 to nearly 21, Jordan had been confined in juvenile facilities, separated from his family, and labeled a murderer. His education, social development, and formative years had all been spent in custody for a crime the courts ultimately determined he did not commit. After his release, Jordan filed a federal civil rights lawsuit against the state police officers and Lawrence County, alleging that they had fabricated evidence and ignored exculpatory information in their rush to judgment. The suit was settled in 2020 for an undisclosed amount. Jordan Brown's case represents one of the most egregious miscarriages of justice in the juvenile system, said Marsha Levick of the Juvenile Law Center, which had filed amicus briefs supporting Jordan's appeals. It highlights the danger of rushing to judgment when children are accused of serious crimes, particularly when that rush is fueled by community outrage and media pressure. As of August 2025, the murder of Kenzie Houck and her unborn child remains officially unsolved. Jordan Brown, now in his late 20s, has rebuilt his life as a free man, though the stigma and trauma of his wrongful conviction continue to affect him. His case has become a cautionary tale in juvenile justice training and a powerful example of the potential for wrongful convictions when children face adult-level prosecution. The system failed Jordan Brown at every level, said Richard Leo, a professor of law and psychology at the University of San Francisco, who studies false confessions and wrongful convictions. His case demonstrates why we need special protections for juvenile suspects, including mandatory recording of interrogations, immediate access to counsel, and a higher standard for transferring children to adult court. On May 1st, 2011, in Riverside County, California, a family's violent legacy culminated in tragedy when 10-year-old Joseph Hall shot and killed his father, Jeff Hall, as the man slept on the family's living room couch. The case would become notable not only for the killer's young age. Joseph was among the youngest defendants ever charged with intentional homicide in modern US history, but also for the extraordinary circumstances that led to the crime. Jeff Hall was no ordinary victim. The 32-year-old was a rising star in the National Socialist Movement, the largest neo-Nazi organization in the United States. As the group's Southwest regional leader, he organized armed border patrols targeting immigrants and held regular white supremacist rallies at his home, events his children were required to attend. Just hours before his death, Hall had hosted a meeting of neo-Nazi members at his home. His son Joseph was present, as he had been for countless similar gatherings throughout his short life. According to police reports and court records, at approximately 4 a.m., Joseph retrieved his father's .357 revolver from a shelf, approached his sleeping father, and shot him at point-blank range in the head. He then placed the gun on the couch and went to his room. When police responded to the emergency call placed by Joseph's stepmother, the boy immediately confessed. "I shot Dad," he told officers, according to the police report. When asked why, Joseph gave a series of explanations that ranged from wanting to end his father's abuse to preventing the family from being evicted from their home. The case immediately presented Riverside County prosecutors with an extraordinary legal and ethical dilemma. Joseph was only 10 years old, a fourth grader who, under normal circumstances, would be considered too young to fully understand the permanence of death or the full moral implications of murder. After careful consideration, District Attorney Paul Zellerbach decided to file the case in juvenile court rather than seeking to try Joseph as an adult. While this is a tragic and sobering case, we must remember that the perpetrator is a child, Zellerbach stated at a press conference announcing the charges. The juvenile system was created precisely for cases like this, where rehabilitation must be the primary goal. Joseph's murder trial began in October 2012. His public defender, Matthew Hardy, did not dispute that Joseph had killed his father, but argued that the boy's actions were the product of both his young age and the violent, abusive environment in which he had been raised. Court records and testimony painted a disturbing picture of Joseph's upbringing. Child Protective Services had been called to the Hall home multiple times to investigate reports of abuse. Joseph had been kicked out of multiple schools for violent behavior that included attempting to strangle a teacher with a telephone cord. Psychological evaluations revealed that he had been exposed to drug use, domestic violence, and his father's extremist activities throughout his formative years. Dr. Faye Gersh, a forensic psychologist who evaluated Joseph, testified that he suffered from developmental delays, attention deficit disorder, and attachment disorder stemming from chronic neglect and abuse. Joseph has lived his entire life in an environment where violence was not just accepted but celebrated, Dr. Gersh told the court. His moral development has been fundamentally compromised by this exposure. Prosecutors acknowledged these mitigating factors, but emphasized that Joseph had shown an understanding of his actions. They pointed to statements he had made to police indicating that he knew shooting his father would kill him and that killing was wrong. They also presented evidence that Joseph had threatened family members with violence in the past. On January 14, 2013, after considering testimony from over 40 witnesses, Riverside County Superior Court Judge Jean Leonard found Joseph guilty of second-degree murder. In a lengthy ruling, she acknowledged Joseph's troubled upbringing, but concluded that he understood the wrongfulness of his actions when he pulled the trigger. "This was not an impulsive act," Judge Leonard stated. "He thought about the consequences and he decided to kill his father." At Joseph's sentencing hearing in October 2013, Judge Leonard ordered him committed to a state juvenile facility until age 23, with his placement to be determined based on his therapeutic needs rather than purely punitive considerations. The judge specifically rejected housing him with older, more hardened juvenile offenders, instead directing that he receive intensive mental health treatment in a more structured, therapeutic environment. The goal in this case must be rehabilitation, Judge Leonard emphasized. Joseph's young age, his history of abuse, and his developmental issues all point to the potential for meaningful change with proper intervention. Joseph's case attracted national attention, prompting discussions about the intersection of childhood development, exposure to extremism, and juvenile justice. It also raised questions about societal failures to protect children from dangerous home environments. The Joseph Hall case represents a perfect storm of risk factors for juvenile violence, said Dr. James Garbarino, author of Lost Boys, Why Our Sons Turn Violent and How We Can Save Them, in a 2016 analysis. Exposure to violence, ideological extremism, untreated mental health issues, and access to weapons all converged in this tragedy. In 2016, Joseph's attorneys filed an appeal challenging his conviction, arguing that at age 10, he had been too young to understand his Miranda rights or to competently assist in his own defense. The California Supreme Court rejected this appeal in 2015, and the U.S. Supreme Court declined to hear the case in 2017. As of August 2025, Joseph Hall has been released from state custody, having served his full juvenile term until age 23. According to public records, his post-release adjustment has been challenging but supported by ongoing mental health services and strict supervision. His case continues to be cited in legal and psychological literature as an extreme example of how childhood trauma, exposure to violent ideology, and systemic failures can converge to create tragedy. It also serves as a reminder of the unique challenges posed by very young offenders in a system designed primarily for adolescents and adults. The 10 cases we've examined span more than 6 decades of American juvenile justice, documenting a complex evolution in how our society and legal system respond when children commit acts of extreme violence. These cases are statistically rare. Juvenile homicide represents less than 10% of all murders in the United States, but their impact on policy, law, and public perception has been profound and far-reaching. Each case forced communities, courts, and legislatures to confront fundamental questions about childhood, culpability, and the purpose of criminal sanctions. The institutional responses to juvenile violence have also evolved. Many states have developed specialized assessment protocols for young offenders, expanded mental health services in both schools and detention facilities, and created more nuanced sentencing options that balance accountability with the potential for rehabilitation. Yet challenges remain. Access to effective mental health services, particularly in rural and economically disadvantaged areas, continues to be inadequate. School threat assessment systems, while improved, still miss crucial warning signs. The disproportionate impact of harsh juvenile justice policies on minority youth remains a persistent concern. As America continues to grapple with the complex phenomenon of juvenile violence, these cases stand as powerful reminders that when violence begins long before adulthood, accountability becomes a question the system is still not fully prepared to answer. The challenge remains to develop approaches that protect public safety while recognizing the unique capacity of children for growth, change, and rehabilitation, even in the wake of the most serious crimes. 10 children, 10 crimes that reshaped the law. Each case a stark reminder that justice, particularly for the youngest offenders, remains an unfinished and evolving concept in American society. If you found this exploration into these shocking cases compelling, please hit the subscribe button and turn on notifications. Share your thoughts in the comments below.